Hello, my name is Joseph Bestreich. I'm an attorney at Feldman, Kramer, and Monaco, mainly focusing on estate planning, elder law, asset protection. Everyone, an adult, should have estate planning documents, regardless of what your assets consist of or whether or not you have children. If you want somebody to make decisions on your behalf, if you're no longer capable of doing so, it's important to have certain estate planning documents known as advance directives. Someone who can make medical decisions for you if you're unable to do so for yourself. Someone who can make financial decisions for you if you're unable to do so for yourself. Your family, your friends don't have the automatic ability to pay your bills or to make medical decisions on your behalf. So it's extraordinarily important that you have somebody who you want to make these types of decisions for you. Many people assume that a spouse has the automatic right to make all of these types of decisions for you. That is incorrect. It is very important that you appoint somebody to make these types of decisions for you. A spouse does not have the authority to go into your own bank account and pay your bills just by virtue of being a spouse. Many people don't even want their spouse to be able to access their accounts. They may be newly married and they may not want their spouse to know all of their assets. It's important that you pick who you want to make these decisions for you. If you were to pass away, not all of your assets go to your spouse. It can go to, if you don't have a will that dictates where your assets are going, the New York State does not say that everything goes to a spouse. If you have children, even if they're minors, the property would be split amongst your spouse and those children. And if those children are minors, you're going to need a court order, or your executor is going to need a court order to access those funds for the benefit of your children. Even if you do have beneficiaries that are going directly to a person upon your passing, it's still very important to have a will, especially if you have minor children. That is because you would still, in your will, appoint who you would like to be the guardian of your children if both you and their other parent were no longer around to care for those minor children. And it may not be someone who you think would automatically be a guardian of your child. So a will is still very important to have, even if none of your assets are going through your will, because it would still be a place where you would dictate who you would want to be the guardian of your children after you pass away. Many people believe that they should list their minor children as backup beneficiaries on all their accounts in order to avoid their will and avoid probate. The reason why we typically do not recommend this is because if you have minor children who are the beneficiaries of your accounts, they will be able to access all of those funds at 18 years of age. And that typically is not the way in which people would want their children to inherit their assets. The cost of not planning ahead with these types of documents would be having people who aren't in a great position to make certain decisions on your behalf being thrust into that position, as well as people who you may not want making certain decisions on your behalf, whether that be healthcare decisions, whether that be who is caring for your children after you pass away, and who may be able to access your finances. Those types of people who you do not want to act on your behalf being able to do so. So if you do not plan ahead, then you're going to possibly have a situation in which you're not going to like the end result.